my bids a little higher, but Jeff brought the question, Jeff was higher. But Jeff brought the question on these bid documents. On number 4, it says all bidders must be pre-qualified by the Commonwealth of Kentucky Transportation Commission. Okay, now Butch said he wasn't sure, he didn't know if Mike had that certification or not, but Jeff does. And then Mountaineers, Jimmy Cox Mountaineer, he shows a sample of what that looks like. He had a copy with him.
It's never been required to have it until now. I mean, it's never been required.
Well, that's what they never required before, but it is in bid document.
There was not a requirement before, and there was a change made for this year. It was based on the Commonwealth of Kentucky's recommendations for these type of bids. That's why it was included this year and was explicitly stated, I believe, in the advertisement for the bids, that there would have to be that requirement. The position of the fiscal court, given that the circumstances are a little different this year, I can only say that if it was a qualifying bid on every other facet, but the certification was not yet turned in, if you all would allow for them time to show that they had the certification, even though it wasn't pre-approved, given that it's the first time that that's been done, you all can accept that. Now, you are completely covered by what was actually listed. It was listed that was a requirement. Therefore, you can refuse that bid if you choose to. But the recommendation I'm making is because this is the first time that's actually had to be in there and they had to be approved ahead of time, that if you're going to make any exception to that, that it's going to have to be done on a separate fiscal court day. You're going to have to repost that particular portion of the gravel, because I know that doesn't affect every single bid, it's just gravel on gravel. But we would have to repost it, giving opportunity for everyone to put new bids in. Now, I don't know what that's going to do as far as just from a practical matter, being able to push things back, if that's going to slow down any type of work that's being done or anything like that. That's consideration that you need to think about. But if you're going to make any type of special condition allowing someone to come back in now and show that they've now been approved by the state, then every single bid on that gravel has to be redone. Because it was properly posted as that was a requirement. If it wasn't posted, it'd be different issue. But because it was listed saying that is a requirement, anything that come in that don't actually say that is not a qualifying bid.
They all got the same bid package. So y'all understand what he's telling us? Is it you might have to reopen the bids or accept it as it is?
The only thing I see is it's gonna cost us 50 more cents on ton.
Yeah.
You figure it across the board, it's gonna be a lot. That's my concern. You got, some of them's $1.30, some of them 50 cents, some of them 65 cents.
Now, understand that if it's reopened for bidding, they don't have to stand by those bids they have now. They can completely change. So, I mean, I understand you're trying to kind of speculate out, but.
Right, I mean, I'm just trying to toss everything around here, I mean.
Yeah.
So it costs more money.
It's gonna cost us 50 cents more ton over a piece of paper. That's what it amounts to. You take all your gravel down, that's a lot of money.
It does.
Well, I like them both. They're both friends, but will they be subject to a lawsuit or Jeff done what was according to rule? I mean, if we deny him, you bid.
You are, let me put it this way. He could bring suit if he is given the opportunity to bid again, and these first round is not actually used. Then I believe that we're going to be successful in defending a lawsuit, but we are going to probably defend a lawsuit. Does that ring true? I mean, what I'm saying is he could very well bring suit. I think we'll be okay if the county does show that they are making strides to bids as they were properly listed, and those are the ones you have to go on.
And he did part of the qualification.
I know it's a fiscal consideration, and that is a substantial fiscal consideration, 50 cents is not a difference. But if we're talking about what was properly done by the procedure that is prescribed for us, you need to just accept the bids as is.
Should we go in closed session on this, you think, just to discuss?
We can, I'm fine with discussing it with everyone, but if anyone has any particular questions, then by all means.
Did y'all want to go in closed session to discuss this?
Let me ask Butch one question. Butch, did you know you were supposed to have that done or not?
No, sir.
We assumed that as long as the query was qualified, that was an assumption we made since we'd never been required to have one before. We assumed that as long as the query was certified, that it would carry on, you know, that's the product we're selling is their product.
Effect on July 1st, can it still be accepted?
Because the package went out and says the bidders, as they were, must have met these qualifications ahead of time. You can't go back and throw out all these bids, all the qualifying bids now and bring in extra. That's what I'm saying from a legal standpoint, because we discussed it, the possibility of just opening it back up and allowing everybody a chance to get all of this. But from a legal standpoint, I cannot recommend that the county do that, because as it stands now, it would be making special dispensations to you all against another qualified bidder who did meet each requirement in there. And that's going to open the county up to any type of civil lawsuit.